Hannah never imagined she would be sitting in a courtroom facing her own parents. She had given everything to her children. Every early morning, every school run, every fever at 2 in the morning, every moment that motherhood asked of her, she had shown up for all of it. Completely, consistently, without asking for recognition or applause because that was never why she did it. But her parents had decided she was unfit. They had filed paperwork, hired an attorney, built a case from carefully selected moments and strategic omissions, and the particular confidence of people who believed that being older and louder and more organized made them right. They had prepared for months. Hannah had prepared for longer. Because 11 months before that courtroom, on an ordinary Tuesday evening at her parents' kitchen table, Hannah had pressed record on her phone and slipped it into her bag. She hadn't known exactly what she was recording for. She just knew that something was being built against her and that the truth needed a witness that couldn't be cross-examined. 47 minutes. That recording sat on her phone for 11 months. Through every legal filing, every court date, every sleepless night of wondering if she was going to lose, then the moment came. She pressed play, the judge removed her glasses, and everything her parents had spent months constructing came apart in 47 minutes flat. 11 months, 47 minutes. One press of play, subscribe and ring that bell, because what comes out of that recording is something her parents never imagined would be heard in a courtroom. My name is Hannah Carr. I'm 34 years old and I live in Sacramento, California. 3 years ago, my marriage ended in the particular way that marriages end when the trust at the center of them is gone, and both people have known it for long enough that the ending feels more like acknowledgement than surprise. I have two children, Eli, who is 7, and Sophie, who is 5. They are my entire life in the most literal and non-hyperbolic sense of that phrase. Everything I have built since the divorce, the apartment, the routine, the carefully constructed stability of our daily life, has been built around them, and for them, and because of them. I did not expect that building to be challenged. I especially did not expect the challenge to come from my own parents. My relationship with my parents before the divorce was what I would describe as functional love. We were close in the way families are close when everyone has made an unspoken agreement to navigate around the difficult things rather than through them. My mother was warm in specific circumstances and critical in others with a consistency that I had learned to predict and work around. My father was steady and practical and expressed love primarily through showing up rather than through conversation. We had disagreements over the years about my marriage, about choices I made, about the life I was building, but we moved through them and remained intact. I believed going into the hardest period of my life that family meant they would be behind me. I was not entirely wrong about that. I was wrong about what being behind me would look like. The comments started about 4 months after the divorce was finalized. My mother noticed that I was feeding the kids dinner later than she thought was ideal. My father expressed concern about the amount of time Eli was spending on screens during what he called the adjustment period. My mother mentioned twice in 1 week that Sophie seemed quieter than usual, and looked at me when she said it in the way that suggested the quietness was connected to something I was or wasn't doing. Individually, each comment was manageable, the kind of parental feedback that exists in most families and gets absorbed and forgotten. But there was a frequency to it that began to feel less like concern and more like inventory, like someone was keeping a list. I noticed it without knowing yet what the list was for. By month 6 post-divorce, the criticism had found a rhythm that felt deliberate. Every parenting decision I made seemed to arrive at my parents' awareness and return to me with an attached concern. The school I had chosen for Sophie's kindergarten. The pediatrician I had switched to after the divorce when the old one was on my ex-husband's insurance. The evenings when work ran late and I used the after-school program, a program that was excellent and that Eli genuinely loved, framed as evidence of unavailability. None of these things were hidden from my parents. I had shared them openly because I trusted them and because I had always believed that sharing the details of my life with family was what family was for. I was learning that information shared in trust can be collected for purposes that have nothing to do with trust. The confrontation happened on a Sunday in November. I had arrived at my parents' house for what I expected to be a regular afternoon visit, and my mother said something, offhandedly, without apparent awareness of the weight of it, that referenced a specific conversation I had never had with her. A conversation about a parenting decision I had made that she had details about that I had not given her. The only other person who had those details was my ex-husband. I kept my face neutral and asked a careful question, and within 3 exchanges it was confirmed. My parents and my ex-husband had been in regular communication. About me, about my children. about the specific evidence they were each collecting about my fitness as a mother. I drove home from that Sunday visit with my hands steady on the wheel, and something cold and clarifying moving through my chest. I am not a person who acts from panic. 6 years of a difficult marriage, and 3 years of rebuilding after it had taught me that decisions made from the hot center of an emotional response rarely serve you as well as decisions made from the cool edge of it. So I drove home from my parents' house and I let myself feel everything: the betrayal, the fear, the specific grief of understanding that the people who were supposed to be your foundation had been quietly working against it. I felt all of that completely. And then I made a decision. I was going to go back. I was going to sit at that kitchen table again. And the next time my parents had a conversation in front of me that confirmed what I now suspected was being built, I was not going to be the only one who heard it. I chose a Tuesday. Nothing significant about the day, just the next opportunity that presented itself naturally enough not to seem engineered. I arrived at my parents' house with a bottle of wine and the relaxed energy of a daughter coming for an ordinary evening visit. Before I got out of the car, I opened my phone, started a voice recording, turned the screen off, and slid it into the inside pocket of my bag with the microphone facing up. Then I went inside. My mother was cooking. My father was at the kitchen table reading something. I sat down across from him and accepted the glass of wine my mother poured and let the evening begin at its own pace. The phone was recording. The timestamp read 7:14 p.m. What happened in the next 47 minutes would take 11 months to play in full. The conversation started exactly as I expected: ordinary, warm, the comfortable rhythm of a family evening that had been running the same way for decades. My mother talked about something from her garden club. My father asked about Eli's soccer. I answered everything naturally and let the evening breathe at its own pace. I had learned from 6 years of a difficult marriage that the most revealing conversations happen after the ordinary ones have lowered everyone's guard sufficiently. So I didn't push toward anything. I refilled my wine when my mother offered. I laughed at the right moments. And somewhere around the 10-minute mark, my father set down the paper he had been half reading and said my ex-husband's name in a tone that told me the ordinary portion of the evening was finished. Within minutes of my ex-husband's name entering the conversation, the full shape of what had been happening became audible in a way that no amount of Sunday afternoon suspicion had fully prepared me for. My parents had been speaking with him regularly. Not occasionally, regularly, with a frequency and a depth of detail that indicated an ongoing and coordinated relationship. My mother described a phone call from the previous week in which he had relayed specific details about a decision I had made regarding Sophie's school schedule. Details he had no first-hand access to, which meant someone had been feeding him information, and that someone was sitting at this kitchen table pouring wine. My hand moved toward my bag once, briefly. I redirected it to my glass and kept my expression exactly where it needed to be. My father was the one who used the word plan. He used it carefully, the way precise people use words they've chosen deliberately, in reference to a sequence of steps that he and my ex-husband had apparently discussed. He didn't detail every element, but what he did say was specific enough to make my blood go cold in the particular way that happens when something you feared turns out to be not only real but further along than you knew. He talked about timing, about the importance of consistency in the documentation they were building, about a threshold they were trying to reach before moving to the next stage. I sat across from him and nodded at a moment that called for nodding and reached into my bag under the table to confirm with one fingertip that the phone was still there and still warm. My mother brought up the attorney approximately 22 minutes into the recording. She said it the way she said things she had been sitting on and was now ready to surface, with a particular casualness that was designed to make significant information sound like ordinary conversation. She had spoken with a family attorney, not hired, spoken with. She described the consultation in enough detail to make clear it had been substantive. She referenced grandparent rights under California family law with a specificity that did not come from casual research. She mentioned that the attorney had outlined what would need to be demonstrated and what documentation would be most useful in demonstrating it. My father listened and asked one clarifying question. I sat between them and listened to my own vulnerability being mapped with the attentiveness of someone taking notes they would never need to write down. The incidents they discussed were real. That was the thing that required the most discipline to sit within that kitchen. The events my parents were planning to present as evidence of my unfitness were actual moments from my actual life, selected and reframed with the particular skill of people who had been paying close attention for months. The evening I had been delayed at work, and the kids had eaten cereal for dinner. presented as neglect. The week Sophie had been sick and missed 4 days of school, framed as educational instability. The one time Eli had arrived at my parents' house without a jacket in cold weather, described as chronic inattention. Each incident is real. Each interpretation is a deliberate distortion of a context that had been carefully stripped away. I counted afterward, when I listened to the recording in the quiet of my apartment with my children asleep. My ex-husband's name appeared 12 times in 47 minutes. 12 references, some brief, some extended, some in context that made the depth of his coordination with my parents unmistakably clear. He had provided them with incidents. He had suggested framings. He had connected them with someone in his professional network who had experience with family court proceedings. He had been an active and central architect of what my parents were building, not a concerned party who had been approached, but an initiating force who had found willing partners in two people who loved their grandchildren and had been persuaded that loving them meant this. The 12th time his name appeared, my mother called him a blessing. I sat with that word for a long time. I drove home from my parents' house at 9:47 p.m. I know the exact time because I checked my phone the moment I got in the car, confirming the recording had run its full duration and the file was intact. It was 47 minutes and 12 seconds of audio, clear and complete. I sat in my car in my parents' driveway for exactly 90 seconds before pulling away, not from hesitation, but from the specific intentionality of someone who understood they were holding something significant and needed to be deliberate about every step that followed. I drove home at the speed limit. I put the kids to bed. Then I sat at my kitchen table and uploaded the recording to my cloud storage, emailed it to a personal account, and saved a copy to an external drive I kept in my desk drawer. 3 locations. Then I went to bed. I did not sleep immediately. But I was ready. I called the family law attorney my friend had recommended at 8:15 the following morning, before the kids were awake, before coffee, before anything else. Her name was Patricia Osai, and she had 17 years of family court experience in Sacramento and the specific kind of calm that comes from having seen everything and remaining unshaken by most of it. I got an appointment for that afternoon. I sat across from her desk and told her what I had. She asked me to play at the beginning. I played the first 10 minutes. At the 10-minute mark, she held up her hand and stopped me. She looked at me across the desk with an expression that was controlled but communicating something clearly. She said, "Do you have the complete file with you?" I took out my phone and handed it to her. Patricia listened to all 47 minutes with her elbows on her desk and her hands folded in front of her mouth. She didn't take notes while it played. She just listened with the focused stillness of someone storing everything precisely. When it ended, she sat back in her chair and looked at the ceiling briefly before looking at me. She told me that the recording was significant for reasons beyond the obvious. In California, she explained, a one-party consent state, the recording was entirely legal. I had been a participant in the conversation and had every right to record it. But its significance went beyond legality. It documented the origin and coordination of what was being built against me in a way that transformed the entire proceeding from a legitimate concern into something the court would view very differently. I left Patricia's office with a specific list of things to do, and I did all of them with the organized precision of someone who understood that preparation was the only thing standing between her children and a courtroom outcome she could not accept. I started a daily log, timestamped entries documenting school pickups, bedtimes, meals, activities, medical appointments, any interaction with my children that demonstrated consistent and attentive parenting. I was already a good mother. Patricia wasn't asking me to become one. She was asking me to create a paper record of what had always been true so that no selective framing of isolated incidents could stand against the full documented picture. I logged everything, every day. Without exception, for the months between that office visit and the court date. The formal filing came on a Thursday morning via my attorney's office. Patricia called before I could open the email, which told me she had been watching for it. My parents had filed a petition for grandparent visitation rights in Sacramento Family Court. The language in the petition was careful and legal and built from the incidents I had heard discussed at the kitchen table, but sanitized now, stripped of the coordination and context the recording contained, presented as the independent observations of concerned grandparents rather than what they actually were. I read the filing twice. Then I called Patricia and told her I was okay. She said she knew. She said they filed exactly what the recording said they were going to file. The documentation of their plan and the execution of it were now sitting in the same legal universe. That mattered enormously. 3 days after my parents filing, my ex-husband filed a motion to revisit the custody arrangement. 3 days. Patricia had told me to watch for it, and I had, and it arrived exactly when the timing of the recording suggested it would. The coordination was now legally visible. Two separate filings, two separate attorneys, arriving within 72 hours of each other, built from the same foundation of incidents and framings that the recording had captured being assembled 11 months earlier. Patricia filed a motion noting the timing and requesting that the proceedings be considered in the same judicial context. The judge assigned to the case granted that request within a week. My parents and my ex-husband had organized themselves so thoroughly that their coordination had become its own evidence before I had played a single second of audio. Patricia laid everything out on her conference table one afternoon in September. The filing, the custody motion, the documentation I had built across 11 months, the recording, the legal analysis of each element. I sat across from it and looked at the full shape of what had been constructed against me and what now existed to answer it. The picture on their side was organized and detailed and built by people who had been working toward it for over a year. The picture on my side was more organized, more detailed, and built by someone who had been inside their planning meeting. Patricia tapped the recording file on her laptop and said something I carried with me to the courtroom. She said, "They prepared a case." Prepared the truth. Those are not the same thing. I woke up before my alarm on the Tuesday of the court date. The Sacramento morning was still dark outside my window. The kids were asleep. They were staying with my friend Diane for the day, who had held my hand through 11 months of this and asked for nothing in return. I made coffee and sat at my kitchen table and did something I hadn't done in a while. I played the recording one more time, all 47 minutes, not from anxiety, from intention. I wanted to carry every word of it into that courtroom with full clarity. I wanted to remember not just what had been said, but how it had been said, the casualness of it, the confidence, the complete absence of any awareness that what was being planned at that kitchen table was being documented by the person it was being planned against. Then I got dressed and drove to the courthouse. The Sacramento courthouse on a Tuesday morning has a specific energy, purposeful, slightly institutional, full of people moving through hallways with the focused quiet of those who have somewhere precise to be, and something significant at stake when they get there. I walked in with Patricia beside me carrying a leather folio that held 11 months of documentation and one audio file that had been sitting on my phone long enough that I had stopped being afraid of it and started simply being ready to use it. I was wearing the navy blazer I wore to things that mattered. My hands were steady. My coffee was still warm in the travel cup I had remembered to bring and then forgotten in Patricia's car, so it was no longer warm but had served its psychological purpose on the drive over. I signed in at the desk and found my seat. My parents' attorney was thorough. I will say that fairly and without minimizing it, he had built a coherent narrative from the material he had been given, and he presented it with professional competence. The incidents arrived in the order I had heard them discussed at the kitchen table 11 months earlier. The late work evenings, Sophie's sick week, the jacket. Several additional incidents I hadn't heard discussed, but recognized immediately as distortions of real moments. Each one plausible in isolation, each one stripped of the context that would have made it unremarkable. The attorney framed my parents as devoted grandparents whose access to their grandchildren had been restricted by a mother whose capacity for consistent care had given them genuine and documented concern. It was a good presentation of incomplete information. I had heard it being written. My ex-husband testified with the practiced composure of someone who had prepared carefully and believed his preparation was sufficient. He spoke about the children warmly and genuinely. Whatever else was true about him, he did love Eli and Sophie, and that came through in ways that were real. But as his testimony continued, the coordination became visible in the courtroom in a way that hadn't been apparent on paper. He referenced incidents my parents had referenced using almost identical language. He described concerns that mirrored their filing with a specificity that suggested a shared source rather than independent observation. Patricia noted each convergence quietly in her legal pad without drawing attention to the notation. The judge, I noticed, had begun watching my ex-husband with the particular attentiveness of someone who has started asking themselves a question about what they're hearing. Patricia began our response with documentation. She was methodical and unhurried, moving through 11 months of daily logs, school records, medical appointment histories, teacher statements, and pediatric notes with the organized calm of someone laying a foundation they know will hold significant weight. Eli's attendance record, perfect. Sophie's medical history, current, consistent, managed attentively. 3 teacher statements describing engaged, present, reliably available parenting. The pediatrician's notes referencing a mother who came prepared to every appointment with written questions and followed up on every recommendation. The picture that emerged from the documentation was not a performance of good mothering. It was the paper record of something that had simply always been true. The opposing attorney objected twice during this section. The judge overruled both times without elaboration. Patricia paused after the documentation section with the deliberate timing of a person who has been building towards something and is now ready to arrive at it. She told the court that the defense had one additional piece of evidence to introduce: an audio recording made 11 months prior that was directly relevant to understanding the nature, origin, and coordination of the case being presented against her client. She stated clearly that the recording had been made legally under California's one-party consent law, that the petitioner's client had been a participant in the recorded conversation, and that its content bore directly on the court's ability to assess the credibility and independence of the concerns being presented. The opposing attorney was on his feet before she finished the sentence. The judge looked at him, then looked at Patricia, then said, "Overruled. Please proceed." The opposing attorney's objection was structured and argued with genuine urgency, relevance, prejudice, foundation. He was good at his job, and he made the best case available to him against the recording's admission. Patricia responded to each point with the particular economy of someone who had anticipated every objection and prepared a precise answer for each. The judge listened to both sides with her glasses on and her hands flat on the bench. When Patricia finished her response, the judge was quiet for a moment. Then she looked at the opposing attorney and said that the recording would be heard in full and that she would make her determinations regarding its weight after doing so. She asked if the court's audio system could accommodate the playback. The clerk confirmed it could. The judge looked at Patricia and said, "Please play the recording from the beginning." The recording began with my mother talking about her garden club. I watched my parents' faces from across the courtroom as their own voices filled the room, ordinary at first, the comfortable rhythm of a family evening, exactly as I had experienced it from the inside 11 months ago. My father's expression was controlled for the first several minutes. My mother looked at her attorney once and then looked at the table in front of her and kept her eyes there. The moment my ex-husband's name appeared for the first time, approximately 10 minutes in, something changed in the courtroom atmosphere in a way that was almost physical. The judge had removed her glasses. She was leaning forward slightly with her elbow on the bench and her chin resting on her hand. She listened to every remaining second of it without moving. The recording ended at 47 minutes and 12 seconds. The clerk stopped the playback, and the courtroom went quiet in a way that felt different from ordinary courtroom quiet. This was the silence of a room full of people who had just heard something that had rearranged their understanding of everything that had preceded it. My parents were looking at the table. My ex-husband was looking at his attorney. His attorney was writing something on his legal pad, with the focused energy of a man doing something with his hands, because he needed something to do with his hands. Patricia was sitting completely still beside me with her hands folded. The judge had put her glasses back on. She looked at the recording equipment for a moment as though confirming it had finished. Then she looked at the room and let the silence exist for a full 30 seconds before speaking. The opposing attorney was on his feet within seconds of the judge opening her mouth. He requested a recess. His voice carried the specific controlled urgency of a professional managing a situation that had developed significantly beyond what his client preparation had anticipated. The judge looked at him with an expression I had been watching develop across 47 minutes of audio, a particular quality of judicial attention that had moved from open evaluation to something more settled and decided. She granted 15 minutes. As the room began to shift and people stood and moved, I stayed in my seat. Patricia leaned close and said 3 words quietly: "She already knows." I looked at the judge's bench as she gathered her papers and disappeared through the side door. The set of her shoulders said everything Patricia's 3 words had said. Patricia and I sat on a bench in the courthouse hallway while the recess ran its 15 minutes. She didn't fill the time with reassurance or strategy or analysis. She had told me what she needed to tell me, and she understood that I didn't need words right now. I watched the hallway. My parents emerged from the courtroom with their attorney and moved to a corner and spoke in low, urgent voices with the tight, compressed body language of people receiving information they hadn't prepared for. My ex-husband stood slightly apart from them, which I noticed, and which told me something about how the 47 minutes had landed on the coordination that had brought all 3 of them into that building together. The 15 minutes passed. The clerk called us back. I stood up and walked back into the courtroom with the steadiest hands I had ever had. The judge spoke with the specific directness that I had come to understand was her natural register, no ornamentation, no preamble beyond what the moment required. She addressed the grandparent petition first. She said that the court had significant concerns about the nature and origin of the petition as presented, that the recording had established a coordinated effort between the petitioners and the respondent's ex-spouse that fundamentally altered the court's assessment of the petition's independence and credibility. She said the documentation presented by the respondent's counsel demonstrated consistent, attentive, and stable parenting across an extended period with no credible counter evidence once the framing of the presented incidents was examined against their full context. She paused and looked at her notes. Then she looked at my parents' attorney and continued. My parents' attorney attempted a final statement after the judge's initial remarks, a professional obligation he discharged with the slightly diminished energy of someone arguing a position they now understood was not going to prevail, but were ethically required to advance regardless. He spoke about the sincerity of his client's concern for their grandchildren, about the genuine love that had motivated the filing, about the desire for a relationship rather than conflict. The judge received all of it with the patient attentiveness of someone who has already decided and is extending professional courtesy to the process of being heard. When he finished, she thanked him. Then she picked up her pen and looked at her notes one final time with the focused quiet of a person making sure everything they're about to say is exactly what they mean to say. She denied the grandparent petition in full. She dismissed the custody modification motion, finding insufficient grounds, and noting the coordination between the filing parties as a factor in her assessment of the motion's credibility. She ordered that legal costs associated with the respondent's defense be addressed in a supplementary hearing. She made one additional statement that she directed not at the attorneys, but at the room, that the court took seriously the use of family court proceedings as instruments of coordinated pressure rather than legitimate legal remedy, and that the record of this case would reflect the court's findings regarding the nature of the filings presented today. She closed her folder. She looked up once at the courtroom generally. Then she stood and the clerk called all of us to rise, and she walked through the side door, and the ruling was complete and it was over. I drove home from the courthouse at 12:43 p.m. on a Tuesday, the same day of the week I had pressed the record 11 months earlier. Sacramento in November was doing its version of almost winter, cool enough for a jacket, bright enough to need sunglasses, the kind of afternoon that feels provisional and clear at the same time. I picked Eli and Sophie up from Diane's house at 3:15. Eli told me about a game he and Diane's son had invented involving couch cushions and a set of rules that changed every round. Sophie had drawn something she described as a horse but which bore equal resemblance to several other animals and was beautiful regardless. I drove them home, made dinner, sat at my own kitchen table while they ate and talked over each other about their day. The apartment was warm. The kids were here. The recording had done what it needed to do, and the life that had always been mine was simply, finally, and completely mine again.